My name is Amanda Ortegon, and I am interviewing Jorge Ortegon. Jorge, can you please explain what you do?
I'm actually a third-year law student at St. Mary's. In the actual, as a student, we read and we answer questions for our professors, but as an actual attorney, you try cases for your clients.
In what areas of law do you think persuasion is necessary?
I think persuasion is necessary in every area of law. For example, in your classic criminal case, you're trying to persuade a jury to rule in favor of your client. You're trying to persuade a judge that you are using the proper methods in persuading the jury. You also want to persuade clients. You want to persuade clients that you would be a strong advocate for their best interests. And another example would be in DTPA, where DTPA, which is in insurance style cases, where you spend more time persuading the actual defendant companies or your opponent, because most of those cases get settled. So what you're trying to do there is you're trying to persuade to them that the facts and the laws work in your favor to help them settle and get you as much money as possible for your case.
Okay, and what persuasive strategy do you feel is most important when trying to persuade an audience?
When trying to persuade an audience in the legal field, I think all four of them. Credibility. You not only want to be credible to your clients, but the more credible you are, the more kind of respect you have in the courtroom. Also, credibility kind of exists with previous cases. The thing called judge-made law, which is law that is actually not black letter, but it's written through experience, through past cases, which jurisdictions like to vote in favor of staying aligned with previous decisions in certain areas. Evidence, for example, is one of the most important things in law. As a law student, it was one of the hardest classes we had to take, and as a lawyer, evidence is essentially what is used to sway the jury or a judge to vote or to rule in your favor. Reasoning, you want to use a structured argument. You want to be clear and concise. You want to be to the point. You want to make the law relate to your facts as much as possible, because the further away it is, the harder it is to actually tie everything together. So if you can say this is A, this is B, that's why C, that's a lot easier than saying this is A, this is B, there's a little bit of C in here, and an argument that isn't as structured is least likely to persuade an audience. And emotional, of course, in family law type situations where you're fighting over custody of a kid, you will put the kids on stand and kind of use their emotions in your favor, who they want to be with, who they prefer to live with, or if they want to live with both their parents, all that. You use kids. Or you can use, in a murder case, you'll use the mother or the siblings or the wife of of the victim, to help persuade the jury to give them the harshest punishment, because they didn't just kill somebody, but they essentially ruined that person's family's life.
Okay, thank you. And what persuasive strategy of the four you just talked about would you most likely use?
Though I think they're all important, I want to use. I plan to practice DTPA insurance style law, so I would have to say reasoning, because you have your credibility, you have your past cases, you have evidence, and you have your emotional, but that all ties in to a structured argument. So I'm going to say reasoning is probably the most important, because I think all the other three fall into that one.
Okay, from my understanding, you've done mock cases before, correct?
Yes.
Okay, in those cases, do you use powerful speech to your audience, as in repetition and emphasis and loud voice and everything?
I prefer to use a louder voice. I prefer to use hand movements, because hand movements, kind of distract the audience from. I think they generate more power, more confidence into what you're saying. A louder voice, not too loud, you don't want to yell, but a louder voice, maybe a deeper voice, to not only help you when you're nervous, but they also help, persuade the listener that you are confident in what you're talking about.
Okay, so say you're at a trial in the future, would you recommend your witnesses to use powerful or powerless speech?
Depends on the situation. If I'm trying to get my clients to prove a point, then I would say powerful. But if if I want my clients to play the victim, then I would say a powerless speech might work in that situation.
Okay, and for the last question, would you say that charisma plays a role when delivering a speech? Why or why not?
I think it does. You want to make yourself sound likable to your audience. You want them to be able to relate to you, because an audience that doesn't relate or doesn't like the speaker will naturally find themselves inclined to think opposite of them. So I think trying to get into the emotions of the audience and trying to help them understand that, you're just like them and relate to you are very important. So yeah, I think charisma plays an important role.
All right, well, thank you for your time.
Thank you.